SwayamPrabha. Digital India. Educated India.
Hello viewers, this is Dr. Ashwini Siwal from Faculty of Law, University of Delhi, and I am here to discuss a very interesting issue in our series called Law, Science and Technology. In today's discussion, we will talk about another important aspect of the interface of law, science and technology, that is health law and policy. Well, dear viewers, we all know that law and policy influence how healthcare system is treated, how the medicines are administered, how the treatment or its bills are being paid, or how the medical or the healthcare system is accessed by the people or by the general populace. So we are here to discuss the entire framework pertaining to health, or entire policy framework, or the entire ecosystem encompassing the policy and legal framework relating to health in India, or to some extent some international developments we will also look and compare. Well, I just want to bring your attention to the fact that the ultimate welfare of the people lies in the welfare or lies in the health, or you may say that if their health is good, then they are happy people, or you may say they are prosper people. So to start with the outset, to start with the topics which I am going to cover on your screen, we will have a background and the brief introduction to the concept of healthcare. Then it is going to cover the conceptual framework for study health policy and the law relating to it. We will also look at the constitutional principles relating to health law, the specific laws that pertains to health in India, and then the issues and challenges which are the concerning and key issues so far as the health laws are concerned. Then we will also look at the solutions to improve healthcare system in India, and some policy issues and some landmark judgments and conclusion, and then some readings I will suggest to you for your further reference. So with this introductory slide, I would like to start with the background and introduction to the concept of healthcare. You all know that the globalization has ensued into such circumstances, or it has bring us to such circumstances which call for a coherent system of global health law and governance. Why this statement is true? Well, in the globalized world, the people do travel a lot, and they for trade, for other sort of engagements, they go to different places. And recently we witnessed the COVID-19 outbreak, where we all saw that the entire world was affected or got affected, barring very few nations which remain least affected or unaffected. But it is the globalized disease which spread across all continents and all jurisdictions. So in such a scenario, it is necessary to have a global health law and governance system, because individual health laws or domestic health laws and domestic systems in place in the respective jurisdictions have not been very effective or have not been very successful. So we need a global governance model and a global health care law, but this is not possible, this is not so easily possible, because the jurisdictions or the different countries have different set of norms prevailing into their respective territories. They have different set of concerns, or they have different set of things to be catered by their laws into their domestic territories. But we will see during our lecture how this idea of global healthcare system and global governance on healthcare may be made possible, and how it is something which is achievable and not something not impossible. Well, when it comes to more to the health care system or to the health law and policy, the sources of health law and policy have been in the Indian context, the Indian constitution, the parliamentary statutes, state and local laws, judicial decisions, and some regulations. So, our local healthcare ecosystem basically revolves around the things which are written there: the constitution, the parliamentary statutes, the state and local laws, the judicial decisions and regulations, and some international treaties as well, which also make a part of the healthcare system, and which is also a source of the healthcare and policy in India. When it comes to introduction, well, as I told you that there are a couple of laws and international treaties which do cater to the healthcare or to cater to the health ecosystem, but it also involves unwritten body of rules, some written and some unwritten body of rules, largely derived from custom and formal enactments, which are recognized as binding among the persons constituting a community or state, so that they will be imposed upon and enforced among those persons by appropriate sanction. So, the laws which are in place to cater to the health segment or health care are written as well as unwritten. They are not purely written, and they are at times made or derived from custom and formal enactments which are recognized as binding among the people. And sometimes these binding laws are not very friendly, or not very you may say congenial, or not so easily acceptable by the society, but yet they are imposed on the society, aimed benefit of the society. And Constitution of India, as you all know, is a grand norm, and every law shall abide by the constitutional principles. So, we will discuss what all constitutional tenets do play a pivotal role when it comes to healthcare system. The law is an umbrella term which may include legislations, ordinances, personal laws, delegated legislations, customs, and even usages and judicial precedents, right. And the law and the policy can influence the healthcare and the way in which it is accessed, the medicine and how it is practiced, the treatments and how the treatments are paid for. So, the law and policy, or specifically the public health law and the policy, or its main focus is on locating the appropriate balance between public regulations of private individuals and corporations, and the ability of those same parties to exercise rights that allow them to function free of overly intrusive government intervention. Well, this balance is very difficult to find or is to attain, because the government focuses on imposing the public with lot of laws, and the idea is to definitely for the welfare of the state, but at times it misfires. And on the other hand, the parties which are imposed with those set of laws, they exercise their right, and they try to preclude the intrusive government intervention. So, that balance between the two aspects, two contrasting aspects, is very difficult to maintain here, but the public health law and policy should focus on attaining this balance, so that we can have some set of rules and regulations and laws and ecosystem on public health, which actually caters to the public health and leads to prosperity, rather than leading to the dispute or leading to the conflict. So, when it comes to understanding the conceptual framework for studying health policy and law, we have different frameworks. One framework is based on broad topical domains, and there are a lot of topical domains in the health, which we will study. The second framework is based upon historically dominant social, political and economic perspectives, and the third framework is based upon the perspectives of key stakeholders. So, when it comes to first domain, we have topical domains, and the broad topical domains are healthcare policy and law, the access to care, quality of care, financing of care, public health policy and law. So, why and how the government regulates in the name of protecting the health, safety and welfare of the general people, bioethics, etc., and focus on the point at which public policy, law, individual morals, societal values and medicine intersect. So, this topical domain brings me to a very interesting point, how far the government is justified in restricting the movement of the people, which we witnessed during the COVID times. It brought lot of welfare, because the COVID-19 to a great extent was curbed by this measure of the government, but at the same time the flip side of it is that a lot of people died of miseries, and hunger, or you may say their plight was immense, that they had to go back to their small villages and towns or to their tribes, and they did not have any means for earning during those difficult times. Government tried its best to cater to their food requirements and to their local medicinal requirements, etc., and vaccination was done by the government. But it was also seen at the same time, during this COVID-19 outbreak, that people in not in India but in many other countries, their movements were stopped and restricted, and people protested vociferously, and they were on streets protesting against the draconian measure taken by the governments. So, such things are to be kept in mind by the government while imposing such norms or such rules, because on the name of healthcare they must not restrain the freedom and liberty or curtail their liberty, though that liberty, which is a constitutional right, does have some reasonable restrictions, and the government definitely exercises those reasonable restrictions when required. So, broad topical domains, in the context of the broad topical domains, while understanding the public policy and health law, we need to have a look at those topical domains, because all healthcare policies and laws should be made with the idea of keeping such interest of the people in mind. So is the case with access to care. People must get the access to care, quality of care, financing. It is very difficult to provide finances to each and every individual by the government. Government cannot afford the entire burden on its own, but some preliminary health care or its promise or assurance should come from the government. So, financing is another topical domain in which or in the context of which this public policy of health care or health law is to be understood. And the bioethics, when the trials for a particular drug or clinical trial for a particular drug is done, how ethically it is done, or when a biological material is used, how ethically it is taken, all such things must be catered to or must be kept into the mind or into the consideration. We all know that there has come an apology from the makers of the Covishield recently, and they have also threatened the word that their vaccine has certain side effects, and they have conducted a study which indicated that there are a lot of side effects of their vaccination. So, such things are happening, so ethical standards should be always the pivotal or should be the pioneer concern of the healthcare providers, right, or for that matter the laws or policies made by the government. So, the focus on the point at which public policy, law, individual morals, societal values and medicine intersect are the primary focuses, or should be the primary focuses of any country while making the public health care policy or the law. Framework 2, in the context of the framework 2, to understand the public health care and policy, we have social, political and economic or their historical evolution. Well, in this context we need to see it from a particular time span. From 1880s to 1960, legal oversight of the practice of medicine was delegated to the medical professionals itself, and from 1960 to 1980, social contract era focuses on enhancing access to care, creating new health insurance programs, Medicare and Medicaid, and passing anti-discrimination laws. And from 90s to today, market for healthcare services and health insurance operate best in the regulated free market environment. Commercial competition and consumer empowerment will lead to the most efficient healthcare system. So, this socio-political, economic, historical evolution of the healthcare policy and law is very important for the viewers to understand that over the period of time, since 1880s, the transition is there, and this shift or transition is I will say that is a good as well as a bad. Well, if I will explain it, then I will tell you that the healthcare service or healthcare system today in the present times since 1990s has seen a paradigm shift, where consumer empowerment is not a very focal point. Rather, commercial competition and commercial exploitation is the focal point of the healthcare service providers, insurance operators and everyone, and the times have changed. So, this is a one framework or one set of framework through which you may understand the healthcare policy and the law. The third framework is the stakeholders framework, where we see it from the point of view of patients, we see it from the point of view of healthcare providers, we see it from the point of view of the governments and the public, insurance companies, employers, private healthcare industries, the research community, interest groups, right. So, when it comes to this particular framework, or when we look at it from this particular framework, we find that patient expects from the from the ecosystem on healthcare or on health, or from the law on health, is something his welfare, is something is affordability, accessibility to the healthcare. What healthcare providers expect is different, or is going to be different. They expect good working conditions, they expect their own health safety, or their own welfare. The governments do have some other agenda. They through these policies and laws, they at times appease the masses, they appease the voters, they try to also bring the welfare to these the masses and to the people. The public sees it from different perspective, insurance companies look at it from a different perspective. So, this is from the stakeholders perspective, or this policy and the legal framework on the health or its foundation is from a different perspective. So, we philosophically understand the healthcare policy and healthcare law from these three perspectives which I have just discussed, that is socio-political, historical, and the one is from the key holders, stakeholders, and one is from the topical side, where we demarcated separate topics, and understood separately. Now, coming to constitutional principles related to health, viewers, as I told you that constitution is a grand norm, and every law, any rule, regulation made on the basis of a constitution or has to be based on the constitution must abide by the basic tenets of the constitution. So, article 21 when it comes to health or the policy on health, every policy on health or every law on the health should be in consonance with the contours of Article 21, of 23, of Article 24, and the Indian Constitution has sufficient provisions for the protection, promotion and growth of every individual, worker and group and vulnerable population in relation to nutrition and health. Well, Constitution promises everything, and the laws consequently or eventually are made in consonance with these constitutional tenets, but the implementation has lot of challenges, and we will talk about the implementations also later on. But our constitution has a robust framework in order to cater to the health sector, and in order to achieve these fundamental goals, various acts and rules have been enacted by the government. Well, when it comes to health laws in India, viewers, India has several health laws that regulate various aspects of health care, including the provision of medical services, the sale of drugs and medical devices, and the protection of public health. Some key health laws in India include the Drug and Cosmetics Acts of 1940. This is a brief overview about the health laws in India, and as I told you that India has lot of laws that regulate various aspects of the health care. It looks after the medical services, it looks after the sale of drugs or regulates the drugs or medical products, etc., and ultimately protects the public health. So, let us have a look at those laws quickly. The Drugs and Cosmetics Act of 1940 regulates the import, manufacture, distribution and sale of drugs and cosmetics in India. It also establishes the Central Drug Standard Control Organization to oversee these activities. Then we have the Clinical Establishments Registration and Regulation Act of year 2010, which aims to regulate clinical establishments such as hospitals, clinics and diagnostic centers to ensure minimum standards of facilities and services, and which is why dear viewers, we have the uniform standards being followed and prevailing in the different diagnostic centers, in the clinics, in the hospitals. And this Clinical Establishment Registration Regulation Act of 2010 is one such law or one such act which ensures the uniformity and minimum standards of facilities and services. Then we have Medical Termination of Pregnancy Act of 1971, which regulates the termination of pregnancies in India and specifies the conditions under which it can be legally performed. Well, my dear viewers, everyone is pretty aware that medical termination of the pregnancy is allowed, but to certain a period of pregnancy it is allowed. Beyond a certain period of pregnancy it is not allowed, and one has to go to the court and seek the permission in the cases of threatened pregnancy, etc., but otherwise it is not allowed. So, the right of fetus is taken care of by the Medical Termination of Pregnancy Act of 1971. Then we have the Transplantation of Human Organs and Tissues Act of 1994, which regulates organ donation and transplantation in India to prevent commercial dealings in organs and ensure ethical practices, and wherein the seekers of organs and donors of organs can register, and the illicit trade on organs is stopped by this very law, or is curtailed, or is looked after by this very law. Then we have Mental Health Care Act of 2017, which provides for the rights of people with mental illness and regulates the admission, treatment and discharge procedures in mental health establishments. Well, this law is again finding significance and becoming very significant in the days of COVID, specifically in the days of COVID, when people were trapped at their houses or were bound to stay and work from home, which resulted into lot of medical and mental issues, and then people had to take care of their mental health. So, this law basically regulates the admission, treatment of the people or sufferers of the medical health, etc. The Food Safety and Standards Act of 2006, which regulates food safety and standards in India, including the manufacture, storage, distribution, sale and import of food products. Well, dear viewers, these are for your references. You may read further about any of these laws whichever attract you, but I am just telling you how robust the Indian healthcare laws are, and how wide the Indian laws are on healthcare system. We have Food Safety and Standards Act, the Indian Public Health Standards. These guidelines developed by the Ministry of Health and Family Welfare for various health facilities to ensure standardization and quality of healthcare services. Then going further, we have the Epidemic Diseases Act of 1897, which provides for the prevention and control of epidemic diseases and empowers the government to take special measures to contain outbreaks. And this is the one law which probably was invoked by our government for the prevention and control of epidemic diseases, and the government took a special measure of lockdowns into various cities and various states in the country, right. In fact, the entire country saw the lockdown for a month long time, because of invocation of this law by the government, where the central government is empowered to take some special measures to control outbreaks. Then Preconception and Prenatal Diagnostic Techniques Act, which is a very popular and most violated in the country at the present juncture. At the present juncture, it is respected, it is playing its good role, but in the past it was violated, or it was sidelined, because it prohibits the use of prenatal diagnostic techniques for determination of the sex of a fetus for non-medical purposes. And our country has been a very heavily criticized country when it comes to prenatal diagnostic techniques or use of these techniques for sex determination for non-medical purposes, right. And a lot of such small radiologists or small town radiologists who did it, who used to do or who has done in the past, lot of such prenatal diagnostic techniques were used by them for determination of the sex, which is prohibited according to this act. No sex selection should take place, but girls even before their very birth were killed or aborted, or fetuses, girl fetuses were killed or aborted on the basis of the sex selection, but this law prohibits it, and it is in good implementation nowadays. But there used to be a time when this was violated, and lot of kickbacks or lot of hushing up of the cases used to take place. Then we have a Pharmacy Act of 1948, which regulates the pharmacy profession in India and governs the education, registration and practice of pharmacists. Well, we all know that pharmacists in the country play a very vital role, but the Act on Pharmacy, that is of 1948, it governs their education, registration and practice of their pharmacy, right. Then Medical Council of India Act, which regulates the medical profession in India and establishes the Medical Council of India to set standards for medical education and practice, which is also a very important law to uplift the health care system or health policy in India. The Dentist Act of 1948 Act, which regulates the dental profession in India and governs their education. Then Nurses and Midwives Act 1947, which governs the education, registration of the nurses and midwives. The National Medical Commission Act of 2019, which has repealed the Indian Medical Council Act of 1956, and it establishes the National Medical Commission by replacing the Indian Medical Council to regulate medical education and practice in India. And this 2019 Act is the of late law, which has brought lot of changes when it is compared or when analogy is drawn with the Indian Medical Council Act of 1956. Then the Clinical Trials Registry India, it is not a law but a national registry for registering clinical trials conducted in India in compliance with the ICMR National Ethical Guidelines for Biomedical and Health Research involving human participants 2070. Well, this is where lot of ethical concerns may arise or are bound to arise, because whenever the clinical trials are conducted, the present ecosystem or present framework requires the ICMR National Ethical Guidelines for Biomedical and Health Research to be followed, but at times they are not followed, and that is why national registry for such trials is there, that is called the Clinical Trials Registry India, which ensures that these ICMR guidelines are followed while doing the clinical trials. But what are the issues and challenges after having look at all the laws or many laws that are prevalent in India? Our healthcare system is not yet very great, or is not yet catering to the requirements of the general populace. So, what are those issues and challenges that we face or we are facing? There are several issues and challenges in Indian health laws that affect the healthcare system and its stakeholders. Some of the key issues and challenges include regulatory complexity. Well, dear viewers, there is a regulatory complexity when it comes to the healthcare sector in India, because it is governed by a complex web of laws. As we just saw that there are many laws, rules and regulations at the central, state and local levels. This regulatory complexity can lead to confusion and inefficiency in implementation and compliance. So, one small hospital in our town has to abide or follow the umpteen number of healthcare laws or health laws. So, there will definitely come to be a challenge, or there is going to be a confusion or inefficiency in implementation and compliance because of this complex web of laws, rules prevailing at the central, at the state level. So, regulatory complexity needs to be avoided or has to be diluted. Then lack of uniformity, there is a lack of uniformity in health laws and standards across different states in India. This can lead to disparities in healthcare services and outcomes. So, when it comes to uniformity on standards, central and state level laws, at times there are inconsistencies, which is why the local state laws or local implementers or stakeholders in a particular state, they may not bring those standards which are prevalent in at the central institutions or at the central level hospitals, etc., or central level labs, etc. So, that lack of uniformity is another issue or a challenge. Inadequate infrastructure and resources, this is one of the most important challenges or issues in the healthcare system or health sector in India, because health laws are there and they are implemented, but their implementation is often hampered by inadequate resources and manpower and infrastructure, which affects the quality and accessibility of the healthcare services. We do not have adequate number of doctors, we do not have adequate number of nurses and midwives, we do not have adequate number of pharmacists, we do not even have adequate number of hospitals, and we do not have adequate number of accessibility to medicines and drugs which are patented or which are costly. So, inadequate infrastructure and resources is one such challenge. Then going ahead with the issues and challenges, we have limited enforcement. So far as all these laws which we just saw are concerned, none of these have very strict enforcement system. Often it is weak, leading to violations and non-compliance by healthcare providers and establishments. Then another issue which is contributing to the problem of poor health care services is the education level and awareness level of the people in India, especially in the rural areas where the people are unaware about the rights and responsibilities, and which is leading to the abuse of the healthcare providers or services there. Then the technological challenges, the rapid advancement of medical technology poses challenges for health laws to keep pace with these developments. Issues such as telemedicine, digital health records require careful regulation, and post COVID or during COVID, telemedicine and digital health care, reliance on the digital health care proliferated multiple times or manifold, and we saw that people used to consult the doctors online, etc., wherein there was a great probability of any health hazard to occur to any patient by getting a wrong diagnosis done by a doctor online, or at times without undergoing a test, the doctor used to prescribe a medicine which is meant for some other illness, but the patient is suffering from some other illness. So, this is a problematic scenario because of the technological changes which have occurred recently, but this is something which may be regulated by not allowing the people without getting the appropriate tests done for a particular ailment, etc. When it comes to digital health records, as I told you that post digitization or technological challenges, technological developments, everything is digitized now, and this require careful regulation, because this is a very sensitive, in fact I will say that most sensitive information of a particular individual which pertains to the health of a person, and any record of a person about his or her health may lead to some advantage to be taken by his opponent, his rival, or by any unscrupulous entity, right. So, digital records require careful regulation. Then commercialization of healthcare, there is a growing concern about the commercialization of healthcare in India with a focus on profit rather than patient care, and this is leading to unethical practices and conflict of interest. Then we have inadequate focus on preventive healthcare. Well, there is really no focus on preventive healthcare in India, because we believe in cure rather than on prevention, and there is a need for greater emphasis on preventive measures to improve the public health. There is a lack of coordination among the departments responsible for implementing health laws. There is inadequate protection of patient rights. While there are laws in place to protect patient rights, such as the Consumer Protection Act 2019, there is a need for stronger enforcement mechanisms and greater awareness among patients about their rights. Now coming specifically to some such concerns which are I will say the most challenging and more problematic, like healthcare and the data protection in the healthcare services or healthcare aspect or spectrum. Well, as I told you that digital records are being made of every information of a person. So, how that data is stored and processed and for what purposes it is stored and processed is something which is very problematic, and is something a cause of concern. So, let us have a look at the prevailing framework on this aspect in India as well as abroad. Well, in India, we have Digital Data Protection Act, or prior to that we were governed by the Information Technology Act, where some of the provisions were pertaining to data protection. But prior to Digital Protection Act of 2023, we did not have any specific law on data protection in India. We had sectoral regulation prevailing here and there, or the framework was a combination of some rules, regulations of government and private bodies. So, data protection is one such concern, and these issues are intertwined, especially in the context of electronic health records and personal health information. Here are some key considerations and challenges regarding data protection in healthcare. Privacy is one such concern, because these two issues are intertwined, and privacy is one such issue. Privacy of patients' health information is paramount. Health data often contains sensitive information that must be safeguarded from unauthorized access or disclosure. Confidentiality of that data. Healthcare providers are required to maintain the confidentiality of patients' health information. This include ensuring that only authorized personnel have access to personal information of persons health information. Then security, healthcare organizations must implement robust security measures to protect health data from cyber threats and breaches. This includes encryption, access controls and regular security audits, which is rarely seen. The security and encryption techniques are rarely used in the small hospitals or in the small setups of catering to the healthcare of the people. So, we see that no such encryption or no such security is in place for data which is very important or personal health information of a person. Then we have a consent, another issue pertaining to a consent in so far as this particular issue is concerned. Patients ideally should have a full control over their health information as to how it is to be used and shared, and they must obtain informed consent before their consent must be obtained by any healthcare provider prior to using their data or their information, except in certain circumstances permitted by law, but it is rarely done. The patients are rarely asked or requested for their consent, etc. Then data minimization, healthcare providers should only collect and retain the minimum amount of data necessary for a specific purpose. This helps reduce the risk of data breaches and unauthorized access. Data accuracy, healthcare providers should ensure that health data is accurate, complete and up to date. Inaccurate information can lead to incorrect diagnosis and treatment decisions, and data sharing to third parties should be in accordance with the applicable laws and regulations. Patients should be informed about how their data will be shared and have the option to opt out if they wish. Further, compliance issues are there. Healthcare providers must comply with the relevant data protection laws and regulations such as Health Insurance Portability and Accountability Act. Like in the US they have HIPAA, and in EU they have General Data Protection Regulation. So, here also in India healthcare providers must comply with relevant data protection laws and regulations. In India we have Digital Data Protection Act of 2023, which basically covers the compliance aspect, or which in its sweep caters to the compliance aspect regarding such international norms like GDPR, or in US like HIPAA. Then we have data retention. Another issue is pertaining to the retention and disposal of health data in accordance with legal and regulatory framework, patient rights. So, overall ensuring data protection in healthcare requires a combination of technical, organizational and legal measures to safeguard patients' privacy and confidentiality while enabling the efficient delivery of healthcare services. But this coherence between the organizations and the legislation makers and the technical providers, technical service providers is rarely seen or is lacking to a great extent. So, what are the challenges related to healthcare in digital age? When it comes to this, we have a lot of challenges, including data breaches. We know that a lot of data breaches are taking place, and the very sensitive information of a person goes into the hands of the unscrupulous person, or is sold, or sometimes exposed to or compromised by the cyber breaches or cyber attacks. Then insider threats are there. Employees at times sell at a very cheap cost such sensitive information to the unscrupulous entities. Then compliance complexity. So, there are a lot of challenges, resources, etc., etc. What are the solutions and policy directions to improve these challenges in the healthcare system in India? It is imperative to discuss it, and a multifaceted approach is required to address these various challenges which are prevailing in the healthcare system in India. Some of the key solutions to help improve the healthcare system in India are as follows: increase healthcare spending, the public spending on healthcare facilities, etc. in rural and reserved areas has increased over the period of time. Strengthen primary health care, the focus should be on the primary health care services and early detection and management of diseases. Improve access to health care services, which is not happening, and lot of other things are there, to harness the technologies. Harnessing the technological developments in providing best health care, or in catering to or treating the ailments, etc., is the need of the hour, and lot of technological developments have taken place which have improved the the current healthcare system prevailing in India or abroad, like telemedicine, electronic health records, mobile health applications, and improvement in the healthcare service providers, their efficiency, etc., which has resulted into overall improvement of the healthcare system, and quality of care over the period of time has also improved, but it comes at a cost. It is not something which comes free, because in the public hospitals the scenario is altogether different, and the things are improving with the initiatives by the government, but not at an expected pace. So, there is a requirement or need of improvising on all such things, and we witness that how well our government implemented or took some measures during the COVID-19 outbreak time by preparing our hospitals, because there was apprehension of lot of patients to be admitted because of the COVID-19 outbreak, but overnight hospitals were prepared, and things were brought, and we did it by just making things on our own, and our Atmanirbhar initiative is the tremendous success, and the lot of people immediately got relief from that initiative, that our country did not face the economic crisis, did not face the health crisis, or socio-political crisis during those difficult times. So, these are some of the concerns which everyone should see, which may improve the healthcare. The most important one in the promotion of research and innovation. Well, research and innovation is one such aspect where multi-pronged improvement is required. It is not something which will see the progress by one, just simply one aspect of it, or by improvement in the one aspect of it. Rather, overall improvement should, or multi-pronged improvement of the innovative culture should lead to that result wherein the research and development will be such where we will be Atmanirbhar again, and we will not be expecting other countries to provide us the technologies, right, and research and innovation required to be encouraged. So, we can improve our healthcare system by implementing these solutions, and we can have better outcomes. What is the solution to protect data in the realm of healthcare? Well, so far as the data, which is a big issue and a problematic concern, some solutions to protect the healthcare data: implement robust cyber security measures, adopt secure communication channels. Well, this is very important that communication channels are secure, they are not vulnerable to hacking, etc. Then implement access controls, and the hospitals particularly they must implement the access control measures, which means that only authorized persons should have access to those devices, or those places where the sensitive information of the people are stored and recorded and kept. Then educate and train people, conduct regular security audits, ensure compliance with the regulations like GDPR, secure mobile devices, etc., and monitor and detect unauthorized access, backup data regularly, implement a data breach response plan, and we may have improvement by implementing these solutions as far as the patient data and ensuring the data of a patient or its privacy is concerned. Now, coming to another aspect of the healthcare, that is healthcare and intellectual property. Well, I told you about research and promotion of the research and innovation. Well, it is seen that in India, the intellectual properties are conferred on the healthcare products, or even on the a lot of healthcare innovations, but the number is yet not very promising or not very convincing, or we must not be complacent that lot of intellectual properties are conferred. So, healthcare and intellectual property intersect in several ways, particularly concerning the protection of pharmaceutical, medical devices, biotechnological innovations, and intellectual property rights such as patents, etc., are conferred, ensuring these innovations or these outcomes of the healthcare creators, etc., are commercialized and made available to the public. But these are often used to protect new inventions in healthcare, and often misused as well by evergreening, etc. So, the government must while maintaining or while upholding a great standard of healthcare system in India, must not ignore that no patent should be granted on something which is already a patented product or already lies into the public domain, and no attempt of evergreening should be encouraged. Rather, it should be stopped or outrightly stopped, so that there should be no monopoly of another 20 years to the patentee on a particular innovation of a drug or a medicine which is already in use. Then regulatory exclusivity. In addition to patents, regulatory agencies like the FDA in the US and CDSCO in India provide periods of market exclusivity for certain types of drugs, such as orphan drugs or those for pediatric use, to incentivize their development. So, this regulatory exclusivity is another kind of exclusivity, because intellectual property also confers an exclusivity, is also an exclusivity which is granted by the regulatory agencies. In the context of India, CDSCO in India provides such exclusivity to certain types of drugs, such as orphan drugs or pediatric use drugs. Then data exclusivity. Some jurisdictions provide data exclusivity which protect the data submitted by a pharmaceutical company to regulatory agencies to prove the safety and efficacy of new drug. This prevents generic competitors from relying on this data for a period of time, even if the patent has expired. And so far as this issue is concerned, data exclusivity is concerned, the data is exclusively kept by the agencies, regulatory agencies, for safety and efficacy of a new drug, but generic companies do try to steal or take that data, and they rely on that data to make the generic version of it. So, the data exclusivity should be upholded and should be taken care of. Healthcare companies also use trade secrets to protect confidential information, such as manufacturing processes or formulations, which can provide a competitive advantage. Then copyright can also protect healthcare related materials such as medical textbooks, software or educational material on medical or on medicines. Trademarks are also used to protect brand names and logos associated with healthcare products, and especially the medical or the medicinal products are protected by trademarks, helping consumers identify and differentiate between different drugs and products, or medicinal products for that matter. Then licensing and technology transfer. Well, IP rights are often licensed or transferred between companies to facilitate the development and commercialization of healthcare innovations, and technologies are transferred to facilitate the development and commercialization, and commercialization brings a lot of revenue, and it also empowers or encourages the innovators or inventors to research more, invent more. So, licensing and technology transfer models should be strengthened by the government. We have biotechnology innovations such as genetically modified organisms used in healthcare. They are also protected by IP rights. Then patents and drug pricing, when it comes to policy on drug pricing, etc. So, pharmaceutical companies often obtain patents for new drugs, granting them exclusive rights to produce and sell the drug for a certain period. This can lead to high drug prices, making access difficult for some patients. So, healthcare and the policy issues in healthcare pertaining to intellectual property protected products are on rise definitely, because at times the drugs are priced exorbitantly, which commoner or which not the common people can afford, right. So, this is one such issue where patented drugs must not be priced very heavily, or their valuation or their pricing should be controlled by the organizations, and it must also not be made too much exorbitant or too much costly. And we have seen that a lot of compulsory licenses on patented drugs are granted by the patent offices also, which also is a part of the policy on curtailing the high priced drugs in India, right, through intellectual property legislations. Then generic drugs and patent expiry. When a patent expires, other companies can produce generic versions of the drug, usually at a lower cost. However, there are often legal battles over patents and attempts to extend them, delaying the availability of generics. So, this is another concern when it comes to IP issues in healthcare, that any patentee who holds a patent tries to keep it green forever and delays the legitimate right of the generics to make the generic versions of those drugs, and it ultimately results into what? Ultimately results in preclusion of the common populace from getting access at an affordable price to a drug. Access to medicines in developing countries face lot of challenges in accessing affordable medicines due to patent protection, etc. Counterfeiting is another issue, and quality control. Well, a lot of cases are on rise on counterfeit drugs and on quality. There are compromises that are taking place. The drugs are being made at local facilities without following the standards, etc., which are counterfeit, and no quality is controlled or managed. So, this is an ongoing challenge which needs to be tackled or taken care of. So, there are a lot of issues which I am skipping. Then healthcare and artificial intelligence, increasingly intersecting area, offering numerous benefits and opportunities for improving patient care, clinical outcomes and operational efficiency. Here are some key aspects of the relationship between healthcare and AI. Medical imaging. AI algorithms can analyze medical images such as X-ray, MRIs and CT scans to assist radiologists in detecting abnormalities and making diagnosis faster and more accurately. Diagnosis and decision support. AI can be used to analyze patient data, including symptoms, medical history and test results, to assist healthcare providers in diagnosing diseases and determining the most effective treatment. Personalized medicine. AI can analyze genetic, clinical and lifestyle data to help healthcare providers tailor treatment plans to individual patients. So, AI has played or is playing a great role, or can play a great role, because it is a new technology which is suggesting, or which is suggestive of or is promising in a sense that it provides a lot of advantages by just assessing or analyzing the symptoms, the data fed into it, or by other means, etc., as highlighted earlier. So, healthcare and AI is one such one such part of the this healthcare policy and law, where the government should definitely look into and should encourage more and more AI tools to come up or to be used in the healthcare facility systems or facilities. There are a couple of notable judgments which you may refer to. Because of the paucity of time, I will not cover these judgments here, but just show you that these are the judgments which you may jot down and refer, and understand how important the healthcare system is for the courts also, where the judicial law making is taking place in favor of the public health care, or to empower or improve the public health care. These are some of the cases which highlight evolving legal framework surrounding healthcare in India, emphasizing the importance of access to healthcare, medical ethics and responsibilities of healthcare providers. So, these cases are on different aspects or dimensions, some are on medical ethics, some are on responsibilities of healthcare, some are on laws of healthcare. And so, to conclude today's lecture, I will say that the comprehensive approach is required involving stakeholders at all levels, including government, healthcare providers, civil society, public, lawmakers, etc., to ensure that relevant and effective landscape comes into existence in India on policy and healthcare. So, this is all viewers. You may write to me on my email ID if in case you have any questions. Thank you so very much for patient hearing and listening, and I look forward to coming to you again with more such interesting lectures in this series called Law, Science and Technology. Thank you very much.